Hello, my name is Tia Godin, and this is my presentation on criminal law. I'm going to go over a few main points that I thought was really interesting in this final. First, I'm going to talk about criminal law versus civil law, and then I'm going to talk about the burden of proof, explaining a little bit more about that, as well as criminal law and civil law. And then I'm also going to talk a little bit about ex post facto law. I thought that was pretty interesting as well. So I'm going to talk about and discuss those in this presentation. Alright, so over the next two slides, I'm going to discuss criminal law and civil law. For those of you who obviously don't know what this is, it kind of might seem similar to you, but as in the next two slides, I'm going to explain the differences between them. They're similar, but there are some minute differences between them. Alright, so here we have criminal law. This basically states a criminal case. More or less, in the criminal case, there has to be some sort of theft, mischievous act, there has to be drugs and or robbery involved in order for it to be a criminal case. Right here on the left, I have listed all of those things that need to be there in order for it to be a criminal case. After that is established, a criminal case is usually against an individual, one person, who is accused of breaking the law by doing one of these things that I've listed here. After that's established, it's going to be the Regina charge approved versus the accused. So that's going to be one of the main things as well. Excuse my sloppy drawing. That's going to be another one of the main things here. So after that is stated, then they're going to go down, and the decision is going to be basically based on evidence, and it has to be beyond reasonable doubt. So that means that there has to be no ifs or buts about it, that the person is guilty. After that, it will fall into a judge and then a jury, and they will decide, if the person is guilty or not guilty, and then the sentence will come out after. This is in a criminal case. For a civil case, it's a little bit different. A civil case is normally two individuals or a group that can't come to an agreement. So this is going to be on a personal injury case, something that falls under a contract, a contest will, someone passes away, and then it also goes underneath a divorce. So these are going to be some of the keen things that go for civil cases. When it's a civil case, it's going to be between a plaintiff and a defendant. A plaintiff is going to start the case, and they're going to be the ones that have the problem against the defendant. A lot of these cases also you'll see with people that are renters, and the plaintiff is the person who owns the property, and the defendant's laying on the rent, such and such, like that. And then after this is taken care of, there's going to be a decision, and it's going to be based off of the balances of probabilities. More or less, it's going to be the evidence that's brought to the trial, depending on how the outcome comes. So there's going to be a pre-settlement trial. There's going to also be a judge here as well. There sometimes could be a jury as well. And then they come up with a final judgment. Usually there isn't a sentence here like any hardcore sentencing. It's just more or less what you're going to do and how you're going to handle the situation, and that's what they decide. Alright, so the burden of proof, this is something that obviously I think is a very good thing that they have. So this basically states that a defendant is presumed innocent until they are found guilty. The prosecution has to prove the case against the defendant, and it's standard beyond reasonable doubt, because the defendant, their liberty could be at stake during this, so it has to be without burden of proof, reasonable doubt, in order to prove somebody guilty. So I put this in here. I thought this was kind of funny. Basically, it says my client admits that her fingerprints were on the knife, but we submit that someone borrowed her fingerprints the night of the murder was committed. So basically, you have to come up with some crazy off-the-wall idea in a situation like this one right here and make the jury believe that this woman is innocent, even though clearly for some reason she isn't if she isn't. So I added this in here as well because there's a lot of different words in here that might confuse people. Not guilty, you would be considered not guilty if any of these words right here came about. Believe not guilty, highly unlikely, unlikely, perhaps, suspected, probably guilty. It has to be guilty beyond reasonable doubt. So in order for someone to be guilty of anything, they have to have this burden of proof, and they have to be 100% sure that this person is guilty of the crime that they committed. Alright, so ex post facto law was something that was pretty interesting to me. I didn't really know too much about it until actually reading about it and taking this class. But from my basic understanding, basically it criminalizes an act that was innocent when it was committed. In my paper, I basically made this little note. You ran over a squirrel and you didn't mean to run over the squirrel, and the next day the mayor makes a law saying running over any animal on purpose or by accident is now considered a crime, and they're going to tell you, oh well, you're going to go to jail basically even though you did it and it wasn't a crime when you did it. It also increases the punishment for a crime after the crime was committed. So if maybe you ran over a squirrel and it was illegal, but then they decided to give you the death penalty a day later because they thought that it was cruel and unheard of running over a squirrel that runs out in front of you. To me, this is something that's interesting, being that not being able to charge somebody for something that wasn't a crime when they committed it. Sometimes people do things and they don't even realize it's a crime. How are you, this keeps it so they're not, being sent to jail for something that they didn't think was a crime when they did it. But then the next day, all of a sudden, oh, you're going to jail for it. All right, so I'm going to talk about the elements of a crime. These are the things that are needed in order for it to be considered a criminal crime. I guess I could go in order, even though these are a little bit out of order. You definitely need actus reus right here. This is basically something must be done and must be evidence to back up that it's there and it's being done. Legal versus moral obligation, it has to be there as well. For say a lifeguard not saving someone, this is a failure to act because in their job that's what they're supposed to do. They're supposed to save somebody. If we're going to go to mens rea now, which is a mental state, basically stating there has to be some sort of recklessness, criminal negligence, accomplice liability, aid a person in committing a crime, strict liability. That'd be like a speeding ticket or statutory rape. You should have known what the speed limit is, and you should know that rape is wrong. So your mental state obviously has to be there as well. I'm going to talk about concurrence now. It has to be present at the same time. So say concurrence of an act of actus reus and metus res, both have to be present in order for it to be an element of this crime. So a woman planning on killing her husband with a knife, but kills him accidentally in a car accident instead. There was an act that caused a crime, basically. And then causation is the act that makes the crime happen as well. If a person is robbed and then they end up having a heart attack and die a year and a half later, the person who robbed them could be charged because it gave them an underlying heart condition. So all of these things right here have to be present in order to have a criminal. Alright, so there are quite a few courtroom procedures that happen, but there are a couple main ones. These 5 right here are going to be the main ones that happen. So in the beginning, you're going to have an arraignment. It's called basically a court appearance, in which the charges against the defendant are read, and they tell you what's going on and why you're there, basically. After that, they're going to go to a preliminary hearing, and the prosecutor presents evidence to the judge in an attempt to show that there is strong suspicion that the person did commit the crime. If the judge convinced that there is strong suspicion that the defendant is held to answer. If not, the charges are dropped. During the second arraignment, it's the Superior Court, 14 days after the arraignment. The hearing could be the same as the first hearing. It really just depends. After that, if it moves on, it goes to the pretrial and the motion. It's basically asking the judge to issue a ruling on a legal matter. Basically, this is to resolve any issues before they take it to a jury trial, maybe get a plea bargain, make the sentencing a little bit less, if that isn't what they want and it doesn't work out in their manner and they can't come to like a meeting point, they're going to go to a jury trial. So basically, both the prosecution and the defense are present at the jury trial. The jury is there to examine the evidence and return a verdict. The judge will interpret the verdict for the sentencing according to the state law. So the judge basically there just to tell you what the sentencing turns out to be if you can't solve the things in the pretrial hearing and motions.